Thank you all for jumping in. I'm just going to wait for one moment while we get organized here, get all our participants in. All right, I think we are probably good to start.
Great. Do you want me to head off?
I'm gonna give you guys introductions, so
okay.
you get to sit back for another minute here.
Okay.
Good evening, everyone who's joining us, and welcome to our webinar, Defending Alaska's Correspondence School Allotment Program, Q&A with Institute for Justice Lawyers. I'm Sarah Montalbano. I am the Education Policy Analyst at Alaska Policy Forum. Please note that we are recording today's webinar and streaming it to our Facebook page. Thank you all so much for joining us to hear from our experts on this important issue. The attorneys will first provide information about the lawsuit against the Correspondence School Allotment Program and answer some common questions, as well as discuss the background and history of school choice litigation. We will then take time for your questions after their presentation concludes. To ask a question at any time, please type it into the Q&A box. Questions might be limited by time. Without further delay, please let me introduce our guest speakers. Kirby West is an attorney at the Institute for Justice. Before joining IJ, Kirby was a private litigation associate and a clerk with the U.S. Court of Appeals. She earned her JD cum laude from Harvard Law School. Very impressive. David Hodges is an attorney on IJ's educational choice team, which successfully argued the landmark educational choice case Espinoza v. Montana Department of Revenue before the United States Supreme Court. He earned his JD at the American University. Thank you both, Ms. West and Mr. Hodges, so much for sharing your time and expertise with us. And I will let you take it away. I'm going to go off camera and mute myself while you guys give your presentation.
Great. Well, thank you so much, Sarah. I'd like to start by thanking the Alaska Policy Forum for putting this on. I've been as I've gotten to know the Alaska Policy Forum a little bit through this case, I've just been so impressed with the work they do and with Sarah and Bethany. So you guys are lucky to have such a dedicated and effective organization. I'm excited to be here to talk about school choice. As Sarah said, we're going to talk a little bit about some of the history of school choice litigation, and then specifically what's going on in Alaska right now. I'm gonna mostly, cover this, and then I'll hand it over to David to let me know if I've forgotten anything. But generally, David will help me with the Q&A section. As Sarah said, David is educational choice only attorney at IJ, so he's a real expert on all of these issues and will be a real asset for that. So to begin with, a little bit about our organization, the Institute for Justice. The Institute for Justice is a public interest litigation firm. We're based in Arlington, Virginia, but we have offices around the country and we litigate all over the country. We litigate in 4 areas: economic freedom, so like the right to earn a living, free speech, property rights, and educational choice. Obviously, that's why we're here today. And I want to talk a little bit about why we work in educational choice. Why do we care about this issue? We're not from Alaska, we're not based in Alaska, so why are we in Alaska talking about educational choice? And there are 2 reasons why we think this is important. The first is the policy reason. We think educational choice is really important because everybody benefits from competition in the market for education. So when you put dollars in the hands of families rather than bureaucrats, and you create an opportunity for innovation in education and lots of different styles of education and kinds of opportunities for different kinds of families. Public schools are great for some kids. I was a public school kid, K through 12, but parents know better than bureaucrats what's right for their families. They know what kind of educational setting is best for their kid. And so that's the policy side of it, of why we think educational choice is a good idea. And then there's the legal side of it. You know, we are a law firm, and courts have recognized parents' legal rights in this realm for a very long time. There's a case from the United States Supreme Court from 1925 called Pierce versus Society of Sisters, where the court said parents have a fundamental, very important right to direct the upbringing and education of their children. And the court has been interested in this right and the interplay of this right with some other issues that I'll talk about a little bit for a long time. And so those are kind of the two aspects of this that we're interested in, the policy side and the legal side. And kind of reflecting that dual interest, our work as an organization is we help advocate for these policies to be enacted. And David does a lot of this work of working with legislators to develop school choice programs and to advocate for them to be passed. And then on the legal side, once they're passed, we defend them if they are challenged in court. And oh boy, are they challenged in court. Anytime there is an educational choice program, you can be certain that it will soon be followed by a legal challenge in court. And before I get to the kind of common types of legal challenges and how that's developed, I'll briefly go over the types of educational choice programs that exist that we've seen. There are four main categories. So there is kind of the traditional voucher program, which is what a lot of people think of when they think of school choice. That's a scholarship program where the state says whatever group they're aiming the scholarship program at, that we will pay the tuition for your child to go to a private school, and you can pick what school. There are tax credit scholarship programs. And so in that system, the scholarship program is run by a nonprofit or private group, but you can get tax credits for donations to those groups to distribute scholarships. The third is individual tax deductions and credits. So that's just what it sounds like. The state gives individual tax credits or deductions for school choice. And then the final type of school choice program is educational savings accounts, which are accounts that are created publicly funded or funded by tax credit donations that allow parents to choose a variety of things. So it could be tuition, but it could be homeschooling. It could be you partially go to public school and partially you enroll in certain courses or supplement your education in that way. So as I said, we once these different kinds of programs are passed, we defend them when they get legally challenged in court. And the way that we do that is not by representing state governments or state legislatures or anything like that. We represent parents. And so we intervene in these cases on behalf of families. We're representing families as our clients who are using these programs and whose kids benefit from these programs. And that's really important because it's not, even though often state governments will want to defend their school choice programs, they don't always. And even when they do, their interests are not exactly the same as the families who are in the program. So it's always important when these huge decisions are being made that parents and kids have a voice in the courtroom when the judge is making those decisions. So before I get to what's going on in Alaska and this challenge in particular, I wanted to kind of give a little background about IJ's work in this field, and it really kind of covers the whole breadth of school choice litigation because we've been doing this for a long time. So initially, opponents of educational choice sought to oppose these programs on the grounds that they violated the Establishment Clause of the First Amendment. And of course, that's the clause of the First Amendment of the United States Constitution that says the government cannot establish a religion. And the argument went, hey, if the government is paying for kids' education at religious schools, isn't that establishing a religion because they're sending, public funds sending kids to religious schools? We represented families in that case. It was called the first case with that style of argument that went to the United States Supreme Court. It was called Zellman versus Simmons-Harris, and it went to the United States Supreme Court in 2002. And we won that case because, as is, I think, very intuitive, what the court said is, listen, the state is not saying here, we love religious schools, so we're giving them money. They're saying we're giving families an opportunity to choose whatever kind of school they think is best for their kid. And if that parent chooses a religious school, that has nothing to do with what the state is doing. It's an independent choice of the parent, of the family, of what kind of private school is best for them, or they could choose a public school. But it's all up to the choice of the family. It's not up to the choice of the state. And there was no violation of the Establishment Clause. So with that kind of line of attack foreclosed, opponents of educational choice moved on to other avenues. And the main one came through state constitutions. So a little history lesson is useful here, a short one, I promise, but 37 state constitutions have what's called Blaine Amendments. And these are named after Senator James Blaine, who in the late 19th century tried to introduce an amendment to the United States Constitution prohibiting funding for sectarian institutions. And the reason he did that was because at that time, the United States had a large influx of Catholic immigrants, and the public schools at that time were de facto Protestant schools. They read the King James Bible in school. They sang Protestant hymns, and the Catholic immigrants didn't want to send their kids to these Protestant schools, which were the public schools, so they would send their kids to Catholic schools, and they were trying to get some assistance from the government to send their kids to Catholic schools. Senator James Blaine was upset by this. There was a lot of anti-Catholic bigotry at that time. He did not succeed in getting a federal constitutional amendment adopted, but his example kind of paved the way for these state constitutional amendments that said state funds cannot go to sectarian schools. And this was code at the time for, again, Catholic schools, because all of the public schools at the time were teaching religion. It was just teaching Protestant kids. So as what challengers would do with the Blaine amendments and the state constitutional amendments is say, hey, maybe it's fine. The Supreme Court has said under the Establishment Clause that this is fine for states to give families money to go to private religious schools, but these state constitutional amendments say don't give any money to sectarian schools. So you can't have a choice program, an educational choice program, if you are allowing people to use state money to go to sectarian schools. And this was a battle that went on for quite some time in the courts, but has recently been pretty resoundingly resolved. So in a pair of cases, Espinoza versus the Montana Department of Revenue in 2020, which David worked on and was on the IJ team that worked on this case, and Carson versus Macon, which happened in we got a decision just last summer, which was also an IJ case. And in that pair of cases, the United States Supreme Court made clear that you cannot argue that state Blaine amendments invalidated school choice programs because they allowed parents to choose religious schools. And what the Supreme Court said there is the First Amendment has another clause. There's not just the Establishment Clause. There's also the Free Exercise Clause. The state cannot either promote the religious practice or the exercise of religion, but it can't discriminate based on the practice of religion or the free exercise of religion either. And if you have an educational choice program that's letting families choose any kind of private school for any reason, but you're singling out for exclusion just religious schools, then that violates the free exercise rights of the families who would have chosen to send their kids to religious schools. And so with this pair of cases, that kind of long debate about, what was the validity of educational choice programs under these state constitutional provisions, it's really that fight is kind of over. The Supreme Court has said, if you have a school choice program, you cannot exclude schools. You can't exclude families who choose religious schools, and you can't exclude schools just because they are religious. That violates the Free Exercise Clause of the First Amendment of the United States Constitution. So The second case I mentioned, that was in 2022. So just last year, we got the decision in that case. And if you're kind of now up to speed on the legal developments in educational choice cases up till now. And it brings us pretty nicely to what's going on in Alaska, because as I'm sure many of you will have already been thinking, there are a couple of differences in Alaska to the kind of cases I've been talking about and the kind of programs I've been talking about. First, in the kind of program, obviously, Alaska's program is unique. The Correspondence School program is not a voucher program. It's not exactly an educational scholarship account program. It's something different, and it's something that came uniquely out of Alaska's geography and establishing correspondence schools to make sure they could educate kids in remote parts of the state. And the kind of public-private partnership of having public correspondence schools, but allowing allotments to be used in private institutions, it's just a little bit unique and a little bit different than other cases that have been litigated. And then the other difference in Alaska from the kind of things I've been talking about is the Alaska state constitution. And it's not totally unique. There are a couple other states that are like this too, but Alaska's amendment is not a traditional Blaine amendment where it says state funds cannot go to sectarian institutions. It says state funds cannot be used for the direct benefit of any religious or other private educational institution. This is Article 7, Section 1 of the Alaska Constitution. So it's a little broader than some of the other Blaine amendments. It doesn't just talk about religion, it talks about any private educational institution, but it says, public funds can't be used for the direct benefit of those institutions. And that brings us to this lawsuit, the lawsuit that David and I are working on right now. There was a complaint filed challenging Alaska's correspondence school program in January of this year. And the basis of it was that state constitutional provision that I just mentioned. And what the argument is that allowing parents to use allotments in private institutions is a clear, violation of that provision of the Alaska Constitution. They rely on some precedent from the Alaska Supreme Court back in 1979 in a case called Sheldon Jackson College versus the state. And in that case, the Alaska Supreme Court struck down a tuition program where the state was giving tuition grants to students at private colleges in Alaska. And they said that that violated Article 7, Section 1 of the Alaska Constitution. So that is really the basis of this lawsuit, is saying, okay, the Alaska Supreme Court has said this. We have this constitutional provision, and what the state and what families are doing with correspondence schools is unconstitutional under these things. And then last summer, the Department of Law in the state of Alaska kind of added a little bit of, fuel to the fire before this lawsuit was even filed by submitting an opinion, a formal opinion that said, in their view, it was probably unconstitutional for families, although not everything under the correspondence school program would be unconstitutional. It probably was unconstitutional for families to be able to get allotments to reimburse them for tuition specifically. This lawsuit is much broader than that. It says basically any kind of expenses, educational expenses that are made through the correspondence school program would be unconstitutional. But the Department of Law said, well, maybe at least part of it is. And that kind of highlights what I was discussing earlier of the importance of having a voice for families in the courtroom when it comes to these kind of cases, because families' interests do not always align with the state interests. Here, we're here to argue that what the families are doing, even if they're using allotments for tuition at private schools, that is totally constitutional under the Alaska Constitution. And, we have a reason to think that. So part of that reason is that as I said, Alaska is not the only state constitution that has this kind of broader ban, not just related to sectarian schools, but related to sectarian and other private schools. One of those other states is Arizona. Arizona has an extremely wide-ranging educational savings account program. But previously, the Arizona Court of Appeals had invalidated a voucher program under Arizona's similar provision of Arizona's constitution. So it was a very similar posture to what we have here, where you have this constitutional provision, you have a state court of appeals saying in a decision under that provision of the Constitution, like, hey, this scholarship grant is unconstitutional. But then in another decision about the educational savings accounts program, the Court of Appeals said, actually, this is different. This is different than a grant of scholarships because educational savings accounts are different. And they're different in a really crucial way of, if you have an educational savings account as a family for your kids, you can use that for tuition at a private school, but you certainly don't have to. As I mentioned earlier, there's a whole array of things that you could do with an educational savings account. You could use it for, private tutoring in, one subject. You could use it to supplement homeschooling or pay for homeschooling materials. You could do it for some courses at a private school, but some courses, online or something like that. You really can design your child's education and use the educational savings account for all the expenses that are encompassed in what you've designed for your child's education. And the Arizona Court of Appeals said, because of that, it's just not really true to say that this money is being used directly for the benefit of private schools. The families sometimes choose private schools, but there's a lot of other things that they decide to do with it. And similarly here, in the correspondence school program, the allotments that families get can be used in a whole variety of ways. And their families have the right to kind of design their child's education, working with the oversight of the correspondence school and the public school teachers who work in the correspondence school. As all of you know much better than I do, you have kind of a lot of leeway of what you decide to do with those allotments and what you get reimbursed for. And so we think the same reasoning should apply here to distinguish that former case and say, it's just not the case that this money is for the direct benefit of any private school. This money is for the direct benefit of all of your children, right? And for your families. And you are the ones who decide what you want to do with it, what your child's education should look like. And that, I think, is something that we are going to be arguing strongly in this case. I don't know that the state will be arguing that alongside of us. Kind of remains to be seen as this case moves forward, but we're certainly going to make that argument. We'll also be making arguments in the case about families' rights under the United States Constitution. I kind of alluded to this earlier, but families also have rights to direct the upbringing of their children under the U.S. Constitution. And so we have some arguments that we plan to make under the U.S. Constitution as well. The status of the case right now, so I mentioned the case was filed in January. The state filed what's called a motion to dismiss, so asking the court to dismiss the case for a couple of kind of technical reasons. And we're kind of waiting for the plaintiff to respond to that and see what they'll do next. And that hasn't been fully briefed yet, so I don't imagine that will happen, or a decision will be made on that prior to the end of the school year. I'm guessing a little bit at this point, which I shouldn't do, but it seems a little bit unlikely given that the briefing isn't done yet. But with all of that said, that was a lot, I know, but David and I are, we're mostly here to answer your questions and just be at your service, and whatever we can help you out with, and anything that we can discuss further or fill you in on, we're happy to do that. So I welcome your questions.
I'm going to come back on camera here. Let's see if my camera will cooperate with me. Please.
While we're waiting, I should have said, David, if you have anything to add that I've neglected to address, I happily accept any amendments.
No, I think that you couldn't have said it better. I couldn't have said it better myself. And I'm looking forward to hearing questions. But while we're waiting for Sarah, maybe I could ask you one. So if I'm an Alaska parent and I'm really worried about what's going to happen, how do you think things are going to play out? How do you anticipate this lawsuit's going to go?
As I was just saying, I hate to make guesses. We never know what courts are going to do. I think one thing that I could say with some reasonable confidence is it's going to take a little while for this to be fully and completely resolved. Whichever way this goes in this court, it's going to get appealed, either by us or by the plaintiffs, depending on who it comes out for at the trial court level. So we won't have, I think a final resolution, unfortunately, for a little while. But I feel strongly that we're right, if that's helpful. I really believe in our claims. I think that we're right on the law. It will remain to be seen what the courts do, but I think we have a fighting chance.
Great.
Thank you all for continuing on without me. I apologize there. I do not know when my camera decided to do that. We are having already a lively Q&A. The first one I would like to ask you is, so would this lawsuit affect all allotment funds or just funds paid to educational institutions that are religious?
So the way that the complaint was framed is that it's challenging all allotment funds. So the complaint is very broad, and its attack against it's religious or non-religious. It's against any time that the funds are being used to reimburse for payment to any kind of private institution.
Remarkable. Thank you for that answer. Another question, what do you say to people who bring the argument against school choice by saying that private schools do not admit all students, such as special needs students, etc.?
David, you want to take this one?
Sure. I mean, the same can be said of public school students, public schools rather. I mean, public schools do not have to admit every single person in their state, even in their neighborhood. Public schools also make lots of determinations about whether a kid fits well at the school. If you talk to lots of parents who have kids with disabilities, they might find that there's a disagreement between the special education director and the family about whether the kid even belongs in the school in the first place. I've worked in cases like that, before, with clients who are not able to send their kids to a public school because of a disagreement between the special education director. Private schools are not for everyone. Public schools are also not for everyone. And the purpose of educational choice programs is to ensure that parents have options. You could have a family in which you have 3 kids. For 2 of the kids, public school works out great. For the 3rd kid, she's being bullied. The education's not working for her. She's more of an artist. The school's more of a STEM school. And she just needs to go to a private school instead.
Yeah, I am that family, actually. My sister and I were K through 12 public school, and my little brother just kind of needed a kick in the pants, and my parents sent him to a private school. So and it worked out great for all of us. We all had, and my husband and I are both public school all the way through, and we have 3 kids. Only one of them is old enough to be in pre-K, but she's in a Catholic school, and we're kind of playing it by ear. We'll see what happens with the other ones. But as David said, every kid is different.
That's wonderful to hear. We have another comment. I don't have a question yet, but I want to thank everyone at IJ for the sterling work they do for individual rights, especially when citizens are up against the state or the federal government. So your reputation has preceded you.
Well, thank you very much.
Another question. This may not be perhaps a legal question, but can we as homeschooling parents truly rely on our correspondence school staff to support homeschooling allotments? If you have thoughts.
Yeah, I don't know if we're best situated to answer that. I don't know. I feel like I don't know enough of the details of the situation of homeschooling parents to give a helpful answer. I'm sorry to say.
Completely okay. Another question. Oh, this one's a long one. Is this lawsuit specifically targeting religious and other private schools according to the state's definition of a private school? How about faith-based tutoring centers? And why is the allotment allowed to go to a parent who may teach his or her child from a faith-based stance, and that's not a sectarian purpose? I'm not completely sure I understood. But if you have thoughts.
Sure. Well, this lawsuit is a broad-based attack on the correspondence school program in the state of Alaska. So there's not really like a sectarian or religious angle to it. This lawsuit is going after all private educational providers, whether they are religious or not. So even though religious students and religious parents may be affected by the lawsuit, they're not specifically being targeted by the lawsuit.
Very interesting. Thank you. I'm going to take moderator's privilege and ask a question that we've heard from parents before this. If there is a ruling against the programs, could we as parents have to pay back allotment funds we have received in the past?
So David has litigated more of these cases than I have. In my experience, I have never seen anything like that happen. And I think it would be incredibly unlikely. But as I said, David has done this more than I have. Even I'll let him maybe express his thoughts as well.
I have the same sentiments as Kirby. I would be shocked if something like that happened. I'm not even sure what the grounds could possibly be if they did something like that. If in the event that we lose, I can't imagine how that would even happen, or the process that would happen that would lead to that happening.
Yeah, there's no like legal mechanism for that to happen, and just politically, it would be so insanely unpopular that even if there were a legal mechanism, I don't really see it as a possibility.
That is reassuring. Thank you very much. Another good question. Is the Alaska State Supreme Court the final authority on this case? Is there any scenario that it could go to the National Supreme Court?
So this is a good question. The Alaska State Supreme Court is the final authority on Alaska law. So when it comes to like the interpretation of what is a direct benefit to a private institution as stated by the Alaska Constitution, the final word on that will be the Alaska Supreme Court. But as I said, we also think we have claims that are plausible under the federal Constitution, under the United States Constitution. And so if we bring those claims, and if we were to lose on the Alaska state claims in the Alaska Supreme Court, we couldn't appeal that to the United States Supreme Court. But any ruling on arguments under the US Constitution that we would make, we could appeal that to the United States Supreme Court. And it's hard to read the tea leaves and say, whether or not the court would grant that, but it would be in play.
That's very good to know. A whole bunch of really fantastic questions. So in your opinion, would the DA's correspondence letter support or hinder the NEA lawsuit? And that relates to another one I'd like us to get to.
David, do you want to take that one?
Sure. So I think that the DLA opinion is not something that, we welcome in a lot of respects, because I think that they gratuitously and also incorrectly went out of their way to cast shade on parts of the program, specifically the parts that relate to the allotment for private school tuition. However, it's out there. There's nothing that anyone can do about it. Like we said at the beginning, we believe that they are wrong, in that regard, and we intend to challenge it. And one of the benefits of having interveners in educational choice cases is that, we can make arguments that the state doesn't, either because the state doesn't have the requisite interest to make those kinds of those arguments, or because the state simply opposes them. And we've been involved in numerous arguments in which the state refused to make an argument either for a tactical reason or because it was simply on the other side of an issue. And the state Supreme Court in numerous cases has in fact recognized that we had it right all along. And the DLA can change its opinion. We welcome converts, but even if they don't, we're still confident that we're on the right side.
That is really helpful information. Thank you. Another question. I learned tonight that Alaska has a broader than required Blaine amendment, as you discussed in your presentation, Kirby. Has the Supreme Court upheld the legislation that required this kind of amendment? Is federal commandeering being held at bay these days?
So for the first part of that question, the Blaine amendments that the Supreme Court has considered so far, so that's in like the Espinoza case that David litigated and the Carson case that I worked on, were not like the Alaska Blaine amendment where they talk about both sectarian and other private institutions. So this isn't something that's been directly really considered by the court before, but I guess it's not broader than required. There's no requirement that a state have a Blaine amendment. In fact, we'd prefer they not have them. So I don't know if I understand that part of the question exactly correctly, but the answer is the court has not yet considered one that's like this.
Thank you for that question. It's the response to that question. Does the fact that we've been doing this since 2015 with private schools as content providers help the case? Does that length of time help the case?
I don't think that it has an effect, one way or another. In one respect, it might help in terms of, just showing that people have been relying on it for a long time, and it's part of like the fabric of the life of Alaskans, of many Alaskans, and it's something that a lot of families rely on. But for good or for ill, if a court views something as constitutional or as unconstitutional, it's the history of its existence, plays a varying role, and is probably not going to be dispositive in how the court looks at the case one way or another.
Thank you for your response to that. Another good one. Was the complaint from a parent or from a lobby or from someone in education? Where did this lawsuit come from?
Sure. So the plaintiffs in the case are parents and teachers who are in the public school system. There's always a lot going on in educational choice cases with, opponents to educational choice and other people that are interested. But the plaintiffs in the case are parents and teachers in the public school system.
Thank you. Another question, I was curious about this myself. How long is it likely to take for a final resolution if it is not dismissed summarily?
It's so hard to say.
Read the tea leaves for me, please.
Yes, even if it is dismissed summarily, it's hard to say because it would be a dismissal would be appealed. So I think, especially because, this isn't the kind of case where one side loses at this level and then, we kind of pack up and go home. Whoever loses will definitely appeal. It's likely headed for the Alaska Supreme Court either way. I don't have, specific expertise on how fast that court system moves. If I had to guess, I would just say more than a year. David, what is your estimation?
Yeah, I think that a joke that I heard in law school was one thing that appellate lawyers love is the endless appeals process. And I think that this case is bound for a lot of appeals and for a lot of, it's going to be a long adventure. So buckle up. We're probably going to be here for a while.
Thank you. It's good to know how long we're in for here. A good question. How do we keep updated on how the lawsuit is progressing?
Yeah, so we have a website, ij.org, and we post all the updates on our cases on our website. So that's one easy way to do it. I'm sure if you get in touch with Sarah as well, or Bethany and the folks at the Alaska Policy Forum, they will also be following this case very closely. So I think either organization would be a good resource to kind of keep an eye on the case.
Yes, we would be happy to assist you with that. Another question that we got beforehand. We have our kids in a private school, but they are discouraging us from dual enrolling in a correspondence school and participating in the allotment program. But we know lots of other families are doing this. What's your advice?
One clarification, I don't know if it's easy for them to say this, but I'm wondering who is discouraging them.
I think it's the private schools. That's
okay.
The impression I got from the question, but I don't think they're online today to ask.
I think what I would just say is it's up to you to make the decisions for your kids' education under the program. I don't see any authority that they have to make that decision for you. I think that would be my take.
That is solid advice. Another question that I'd like to address. As parents of students in a correspondence program, we are worried right now and wondering about the future. What should we think about as we head into the next school year, since it's very unlikely to be wrapped up nicely?
I mean, Kirby and I are both parents, so I think that we empathize with you very strongly. Being a parent is tough. Figuring out your kids' education and the kids' future is even tougher. If I were in your shoes, I would definitely hope for the best in terms of how this lawsuit, will proceed. But I think that it would also, make sense to, just one day, just think through the options. Like if the program gets struck down, for instance, if the worst case scenario happens, where does that put you? I'm not predicting that the worst case scenario will happen. I don't think the worst case scenario will happen, but just as a parent, that's what I would do.
That's very good advice. Another question from our audience tonight. During the possible appeals back and forth, will we as parents have to anticipate some years getting allotments and some year possibly not, on again and off again allotments? Do you think that's likely?
I don't know if I can say if it's likely, but I think it could be possible. It definitely could be possible that if one court says that this is unconstitutional, then it wouldn't be available until that decision would be overturned. So again, I don't know. I wouldn't want to say that it's likely, but I don't think it's impossible, unfortunately.
Thank you for that. Another question. In your estimation, what are the odds that things get worse for us as correspondence school parents after this lawsuit versus getting better for us? By better, I mean being able to use our allotments more broadly. If you will read tea leaves for us again.
Well, I think that probably right now or prior to the lawsuit, you were in probably a best case scenario, or certainly in something approximating what a best case scenario would be, because the law was broadened in 2014 from an already broad type of law where you're able to use your allotments for a lot of different educational expenses. Our goal with the lawsuit or with defending against the lawsuit rather, is to preserve the status quo. And it may be as a consequence of this lawsuit that the Alaska legislature sees how well it has served so many people, our clients, as well as a lot of people who are here on the call, and they decide to broaden the program even further, either by increasing the amount of money that is available to each parent, as well as increasing or expanding the number of educational expenses available. But that's all speculative. And again, I would say that the best case scenario right now is just that the program gets preserved as it is, and it would not be expanded or improved in any way as a result of the lawsuit, as a result, I should say, of us winning the lawsuit.
Great. Thank you for that. That is very important information to know. I believe you mentioned this briefly, Kirby, but the questioner states it a little vaguely. Alaska has a state Supreme Court decision from the past that is pretty bad for school choice. How will that affect this case?
Yeah, so that is the case that I mentioned earlier, Sheldon Jackson. And that is kind of the basis of the opinion that David was talking about and I was talking about earlier, from the state AG office, saying like, well, this might be unconstitutional under this decision from the Alaska Supreme Court, but we really truly believe that that is distinguishable. That case involved grants for private colleges in Alaska for kids to go, or for college students to go to private colleges, and that was the only thing you could do with those grants, right? Those grants were for kids who were going to private colleges, so it's just a one-way path kind of thing. And here with the correspondence school program, the allotments are used in all kinds of ways. There's a whole array of things that parents can choose to do, and you can see from some of the questions that are being asked of what all of you are doing and all of you have chosen for your kids' education, the wide variety there. It's not just tuition at a private school. And so in that context where parents are choosing a whole host of different things, and some of that might be tuition, but a lot of it's not, it's just not natural to say that, oh, these funds are being used for the direct benefit of any private institution. It seems really different than the other programs. So there is a bad case, but we think that this is not like that case.
Thank you for that. That is reassuring. Two related questions in the Q&A here. Have we homeschooling parents missed the opportunity to lobby our legislature to craft bills to support homeschooling and the respective allotments? And the second question is, how can homeschooling parents support IJ specifically for this case?
Well, thank you, so much for your interest in supporting us today. We always really, really appreciate, people showing their support. As far as like homeschoolers go, I mean, if there is, I can speak as someone who talks to legislators all the time. It's very important for you to contact your legislator so that they know, what your reviews are, how you feel about it. And I think that to the extent that you can get in touch with your legislator and, convey like your support of this program, as well as any changes that you might want to make, to this program that would benefit you or people who you know. I think that that's always welcomed by legislators, and I would encourage you to do it. And as far as support, of IJ, whether you're cheering us on or donating, we always welcome people's support.
Thank you for that answer. A more general question we received beforehand. Lots of other states are creating vouchers and programs where the money follows the student. Why can't we do that in Alaska too?
Well, I guess my answer to that would be, it's not necessarily impossible. So some kinds of things might be foreclosed by this state constitutional provision. Like I said, that the case that we're dealing with, the kind of the bad precedent from our view, dealt with a grant for kids to go to private colleges. I think it's possible that under that case, kind of a straight voucher program of just like, we'll pay the tuition for a kid to go to a private school. It would be more analogous, at least, to that that case that's already been decided by the Alaska Supreme Court. But I think that an education savings accounts program, which would just be, a little bit different than the correspondence school program because it would be separate from the public school system entirely. It would just say, parents, families, here is a savings account for your child. Have at it, use this money for whatever you want for your kid's education. I think there we have the same argument that this is different than a specific grant to private institutions. Families will choose a lot of different things to do with that money, and it would be distinguishable for the same reasons that Arizona found that was distinguishable with a similar state constitutional provision there. So I don't think that would be impossible in Alaska. It would just be a matter of legislative will.
And what I'd also add to that is that even if you were, for example, wary about a publicly funded program or even a publicly funded ESA, you could also go with the tax credit program, and tax credit programs, those involve private donations to nonprofit organizations. Those have been almost unanimously upheld by state Supreme Courts that have considered challenges under Blaine amendments, where someone's saying, hey, this is involving, public money funding, sectarian schools or private schools generally. And state Supreme Courts have almost unanimously, or maybe even have unanimously found that private money is distinguishable from public money. And as a result, that the tax credit programs considered on that basis are constitutional.
Thank you for that.
I want to just correct myself based on a comment I saw that I misunderstood the Blaine Amendment question as saying that Blaine amendments are currently required, but the questioner correctly was talking about required as a condition of statehood previously. So I appreciate the correction from that commenter.
We always have really informed audiences, and it's a delight. This Q&A is incredible. Another question that hopefully you will be able to comment on. Alaska's judges are notoriously left-leaning and thus probably not fans of school choice. How much of their decision could be politically influenced rather than using the facts?
I mean, I don't want to cast aspersions on any judges or any courts by any means. But even if it's not a matter of politics, if it's a matter of a differing judicial philosophy as well, it's possible that we would lose at the Alaska Supreme Court or in an Alaska court. We know that could happen. We think, like I said, we have really good arguments, both under Alaska state law and also under federal law. And I guess that kind of would be my second point is, even if the Alaska courts are unfriendly to our claims, we do have these federal claims that we plan to bring. And so, it's not necessarily true that the Alaska courts will be the last word on this. So we'll see what happens.
Yeah. Thank you for that. A quick clarification from a viewer. To be clear, are the plaintiffs asking to end all correspondence programs?
I think that they're effectively doing that, right, Kirby? Because what their argument is that any time that educational expenses go to private vendors, that violates the Alaska Constitution.
Yeah, I guess I could imagine a situation where you have the very traditional correspondence school, you're just getting public school curriculum through the correspondence school and there's no private actor. I can imagine that maybe, but it seems like the way that the correspondence schools operate today, and I saw one comment here about someone was using it for private provision of music lessons. So if you're going to a private company or something for music lessons, that's covered by this current lawsuit. That's how broad this complaint is. It's any kind of private institution at all. So if any private actor is involved, then they're saying that that's unconstitutional.
Wow. Well, thank you for that. That was a good clarification question. Another similar one to one I asked earlier that I do not have all the specifics for, but our homeschool program is limiting us from using our allotment funds to pay for part of the tuition or classes that our kids take from a private school. Is that legal? What do you think?
I don't know that I don't know that I have enough information to know like how that decision is being made. Or what the homeschooling program is. I don't know, David, do you have more of a sense for that?
I'm sorry, I don't.
Yeah, sorry.
No, not a problem. Not a problem. Yes, a wonderful question as well. Our correspondence program has been wonderful for our child's learning needs. Is there anything we can do to help while we wait for this case to be decided?
Again, I think that reaching out to your legislator is always very helpful. At IJ, we like to say that we litigate in the court of law as well as the court of public opinion. And I think that, public opinion is very important here. And, these correspondence programs, I mean, they literally predate Alaska statehood. So it's something that's really woven into the history and the culture and the family life of many generations of Alaskans. So, I think that if you could post on Facebook, you could write a letter to the editor, you could write an op-ed in your local paper about what this program has meant to you and to your family and what it would mean if it were taken away. I think all of these are powerful tools that you can use to influence your friends and neighbors and other decision makers who are thinking about this case.
I think that's an excellent answer. A few more. We have 3 minutes on the clock, and I'm not going to keep you guys over because you are on the East Coast and it is midnight pretty much. So a few quicker questions. What's the mechanism to trigger elevation to federal court if we're not successful at the state level?
Yeah, so if we lost in the Alaska Supreme Court, we would petition for certiorari from the United States Supreme Court. So the United States Supreme Court has pretty much total discretion to decide whether or not it wants to take a case. So we would ask, and who knows what would happen. We think these are kind of unique claims, and it seems like this is the next kind of step in the world of educational choice law. Like I said, we had a huge issue that's just kind of recently been settled, and this seems like kind of the next thing, but you never know what the court's going to do. But as far as the mechanism, that would be us trying to appeal directly from the Alaska Supreme Court to the United States Supreme Court.
That is good to know. Another quick question. What role, if any, can the state of Alaska play on behalf of either party in this suit?
Well, I think that the state of Alaska is really representing its own interests, and there's nothing wrong with that. They were sued, they're defendants, and so their role is basically looking at what their interests are, at what the Constitution says as they see it, and making a defense based on those grounds. As we've seen so far, they seem to be really good in certain areas and less good in others. And so I think that at this point, they're playing, sort of an interesting role. And if they want to, like I said earlier, if they want to come all the way over to our side, the water's fine, we welcome them. But if they don't, we'll be totally fine representing the interests of the parents who are our clients.
I think that's an excellent stopping point for tonight. I'm sorry we have so many open questions, but we are out of time. This is the 1 hour. Yeah, go ahead.
If anyone has pressing questions that they want to contact us, I'm happy to also answer further questions. You can find my contact information pretty easily on the IJ website. So.
Absolutely, and I would be happy to facilitate any questions that need to get answered right away. I will put you in touch with these wonderful guest speakers that we've had tonight. So thank you so much, Ms. West and Mr. Hodges, for joining us. I want to leave all of our viewers tonight with instructions to sign up for APF's newsletter so you're notified of our work on important policy issues like this one. Signing up is easy. If you go to our website, alaskapolicyforum.org, you will see a blue button in the upper left corner with the words sign up for email updates. When you click that button, you'll be given the option to fill in your first and last name, as well as your email address. When you click subscribe, you will receive an email from us with a link. You must click this link to verify your subscription. So thank you, Ms. West and Mr. Hodges, so much for sharing your expertise with us. And thank you all for joining us.
Thank you so much for having us. And thank you everyone for really excellent questions and also for, taking an active role in your kids' education and caring about this issue. We really admire everything that you guys are doing.
Yeah, thank you for a lively Q&A, everyone. One last question. Will this recording be available afterward? I am most equipped to answer that. Yes, it will be. It will be on our Facebook page immediately after this, and then we will also be posting it to our website subsequently. So thank you all, and I hope you all have a good night.
Thanks, you too.
Thank you.